Well, mensa aka the full judgment of a year Sedina Tamakloe. The case no. Now you know, we are going to look at it. A year 94 pages. The truth is that let's see, maybe let's see where time will take us. But at the end of the day, no, let us look at what the judges said. 3 judges in our case. No, so but before that, no, let's go back to the case. You know, April 16th, 2024, in our case, no, by now it was Sedina Tamakloe and then Daniel Axim and all that. So areas of law, we are going to look at the judgment, we are going to read the judgments and all that, and then we will go into the appeal and then see what the appeal judgment and so it's going to be an interesting read. And then first time or subscribing, click the notification bell so you know our latest news via about Sabeka. This video is kindly sponsored by Biogas Expert Engineering. So we here ensure say ensure inflow area to say me send ensure flow of me area and day now here clean water Mr. Biogas Expert Engineering free now bet me from okranoma ba be borehole drilling amount omo infidie latest infidie omo de be clean borehole drilling. They have the best prices on the market. So call them on 054-620-5377. 054-620-5377. No from one moment as you say melodies and a directive or may fine. Now young concept judgment. So say this case commenced on the 30th of January 2019 when the Republic instituted the instant criminal proceedings by the filing of a charge sheet containing 78 counts, but misnumbered as 80 counts, as against the accused persons in various respects. The charges and their particulars are relevant for our purposes and reproduced verbatim here under count 1. It's all here. Sedina Tamakloe. We know the case and all that, but charges are the born no. Not a bako 78. 78. In fact, yes, you are more do court no crano. Normal miss number. Na charges ne do swama numbers ne crano more a mistake. Emma if you more kwa say charges near 80, but charges need na 78. And so this was the ruling. Say it went through all the charges. I mean, we all know what happened to Sedina Tamakloe. There's no time to go through all the 78 charges to read the 78 charges. At the end of the day, she was convicted. What you say because you're charging and say we sika. So these are all the charges where you count 31 and all that. So basically in the 94 page document, from page 1 to maybe page 30 should be the counts. Charges are the bono what you say and all that. Into your man judgments. Okay, I want us to go to ended year. As you say, ended year so, and then we understand what's going on. So basically, that's what's happening. Going through the documents, let's look at. This is the point where the judges read the. Also, my judgments are, the other cases at my judgments. Okay, so I mean, it's the appeal. Appeal no na me nida judgment nearby from the appeal no, and I measure. Into let's keep on going. Let's keep on going. Let's keep on going. So where is the appeal? So let's see. So Ebusian for this is the appeal or say Sedina Christian Tamakloe Ationu, first accused, and all that. Now, judgments. We every E and Kama J.A. into the Justice of the Appeals Court. I'll say, preface. My lords, the foundation of this opinion is inspired by the eloquent statements of our criminal jurisprudence by the eminent jurist Ankama JSC, as he then was, in the seminal decision in Ecole Russell versus the Republic, 2017. Also, the strength of our criminal justice system over the years has not thrived on mere wishes and speculation, but by the production of evidence that meets the standard of proof of crime in a court of justice. Enti Oshe Judge Bakon, then Samuel Walker, and then the opening phrase and a clause, the opening statement, our de Kasana, also who judge in Samuel Becca. I'll say Ghana Mbrano ni 2 mino. Enjina yese so. Na Ghana Mbra 2 mino, ejina evidence eso. Evidence a o de try ye be hu say indeed nipa we de odi bone enye yese. Into from that statement also to me hu say judge no ruling a wo ba be man. It's from a certain angle. Now, introduction. I say, my lords, the first accused stroke appellant is praying this court to set aside her conviction and sentencing rendered by the High Court, Financial Crimes Division on 16th April 2024. The appellant and one other accused by the name Daniel Axim, the second accused, were charged with 78 counts of the following offenses: conspiracy to steal, stealing, conspiracy to willfully cause financial loss to the state, willfully causing financial loss to the state, causing loss to public property, improper payment of public funds, money laundering, unauthorized commitment resulting in financial obligations for the government, and contravention of the Public Procurement Act, and all that. Now, background, or say facts presented by the prosecution, or say the antecedents that culminated in the criminal charges against the appellants before the High Courts are next detailed. The Microfinance and Small Loans Center, MASLOC, is an agency of Government of Ghana that primarily offers microcredits and small loans to startups and small businesses, providing them with accessible financing to augment their operations across Ghana. The appellant was the Chief Executive Officer of MASLOC from November 2013 to January 2017. The second accused was the Operations Manager at MASLOC. So this is the judge explaining. Now, say Iyoko's investigations disclosed that in June 2014, as part of MASLOC's operations, it invested a sum of 150,000 Ghana cedis in Obatampa Microfinance Company Limited, a licensed Tier 2 microfinance company in Ejura, Ashanti region. Subsequently, the appellant offered another investment of 500,000 Ghana cedis in Obatampa, and a MASLOC ADB bank check dated 24 July 2014. For that investment amount was drawn in favor of Obatampa. When Obatampa received the ADB check, its board chair was informed by the appellant that the investment of 500,000 Ghana cedis would attract a 24% interest. However, Obatampa decided against this investment because it considered the interest rates to be excessive and issued a check to refund the 500,000 Ghana cedis. Nti ye kan se nsem na ebie mu no etre se MASLOC ekokobo eye a company bi bosia a ye mo 500,000 Ghana cedis and ye tro mo say interest e was 24%. Ye say company no say that be interest ne sondo do nti monje back musika. O say when Obatampa presented the check to MASLOC, the appellant declined to accept and instead demanded a cash payment of the 500,000 Ghana cedis. On the night of 28 August 2014, the board chairman of Obatampa delivered a cash amount of 500,000 Ghana cedis to the appellant at the Bachona Total filling station on the Spintex Road, Accra. The appellant, in a letter dated 28 August 2014, acknowledged receipt of the refund from Obatampa. In 2015, Maslock sent demand letters to Obatampa for the payment of interest on the 500,000 Ghana cedis investment. Obatampa responded by asserting that Maslock's demands were unjustified and reminded the appellants of the cash refund. There were no further demands from Maslock after the response from Obatampa. Enti mami case no ene ni ebiemu Ghana for ye tin sem na se. Asem ni bia enam so ende ya charge mami ni company bi wo Kumasi a efe no Obatampa. Company no omo nkrofo bosia. Enti Maslock ekokomo mo 500,000 Ghana cedis. Eno mo katro mo say I was mutia interest 24%. And a company said that be interest ni sondodo. Inti monye mo 500,000. Inti yase ye mami eye Sedina Tamakloe. Said that be 500,000 no. Dabi. Men fama me check, fama me cash. Inti Obatampa sa company no omo penyi no eba be share Sedina Tamakloe. E was Spinters. Eno disi kana mano. But omo wo hwa ne say Maslock asanso atro. Ama the same company say, "Hey, yesike insi hu 24% na we hi." Eno Obatampa ne trend say, "Hey, musika no refi say mese mempebium. Ama the sika na ba be ma mu panyi." Nti asem a wo ken de sika bi anime wo. You see from there Maslock no embisa for the interest again. It was in 2017 Maslock had a new chief executive officer who sent another demand notice to Obatampa for the payment of accrued interest. In 2017, Abanfo Fraba. It's Abanfo Fraba, ono so checking on books who say, Obatampa mu de yenka. It's Abanfo Fraba ba betromo Obatampa ne say, Masa, yesika we. Thus in 2017, Maslock had a new chief executive officer who sent another demand notice to Obatampa for the payment of accrued interest on the 500,000 Ghana cedis. Again, Obatampa informed Maslock that the investments had already been returned to Maslock. Iyoko's investigation revealed that Maslock did not have any record of receiving the refund of 500,000 Ghana cedis from Obatampa. It concluded that the appellants had appropriated the sum of 500,000 which was delivered to her by Obatampa. The MPP ba no mbehu say system ni mu tre say ye the 500,000 akwa komo Obatampa. Obatampa so tre so the sikana ma ye Sedina Tamakloe. Inti MPP time ena yoku for a year's investigation. Sedina Tamakloe sikano we here one tro e was system ni mu. Part of omu cases. Now the further investigation by Yoko showed that in April 2016, the appellant received approval from the board of Maslock to utilize the sum of 1.7 million Ghana cedis of its funds for a nationwide sensitization and monitoring program for 85,300 beneficiaries of Maslock loans. The targeted beneficiaries were to receive 20 cedis to cover transportation and refreshments. The appellants and the second accused from April 2016 to December 2016 withdrew 1.8 million in tranches despite receiving board approval for 1.7 million. Despite withdrawing 1.8, only 1,300 was spent on beneficiaries in the Volta, Greater Accra, and Brong-Ahafo regions. No sensitization or monitoring program were conducted in the other regions. Inti one of the charges I yede bo maame Sedina Tamakloe yede chi ne tumu no. Se ejwadefo baako beye 85,000 and crofo beye 85,000. Ayema to me say onko yisika na yemfa emwa sankrofo yi enye program bi. Na sike okoko yiye ana sike ayema ne kwanse wonko yi ne 1.7 million. At the end of the day, anka ose okokoche 1.7 million ema Ghana foi ejwadefo yi anambai. Sike wanfa nko. Sika okoko yiye kra 1.8 instead of 1.7. Na enu ye kohwe mu no, omo a wo mo si omo nya sika ni bi no. Ye kan sika wo chemo omo a just 1,000 cedis 1,003. That is a sika nkai no afa he. One of the charges I had born no. As a moreover, even before the board's approval of 1.7 million, in April 2016 for a nationwide sensitization and monitoring program, the appellant had appropriated $246,280 intended for training, sensitization, and financial literacy. Ansa na saa asem ne krabeba no, over 200,000 Ghana cedis bi. Yenhu bebi a wode afa na se sika no nso no, na also di training nkrofo bi. Ede bo mo kokko. Ede tre wo mo sikasem. Also, according to Iyoko investigations, in 2013, Maslock was authorized by then President John Dramani Mahama to provide financial assistance to victims of the Kantamanto market fire disaster. This assistance was to be done through 24 Adamfo Savings and Loans Company Limited, 24 Adamfo, by disbursing 1.4 million Ghana cedis to the victims. However, I'm sorry, I'm just running off the figures, understand, right? However, investigation shows that the appellant appropriated 579,000 Ghana cedis 800 out of 1.4. Into which charges are Sanso de Bona, Kantamanto Eshe. His Excellency John Dramani Mahama, Ekatre Maslock say, Omwa, Jadifona, Omunyama Shen, Omumpe Sikamfa Momo. Into Sika ye kasi ye komomo, 1.4 million. You see, Mami allegedly no. Sika, odiko koma wamono. Enduru. Ena Sikano, emu over 500,000 Ghana cedis. Ye nim di odi Sikano kokoye. Just say, anko engrofu yo. As I also say, in August 2016, the appellant acting for and on behalf of Maslock addressed correspondence to the Public Procurement Authority requesting approval pursuant to the Public Procurement Act for the procurement of vehicles from Mac Autos and Spare Parts Limited for the benefit of the GPRTU by means of single source procurement method. The PPA, in response, requested Maslock to provide it with financial arrangements as approved by the Finance Ministry. On 5th December 2016, the Minister for Finance wrote to the PPA to confirm financial arrangements under consideration for the procurement of the vehicles. The appellant, without obtaining any approval from the PPA, executed a contract with Mac Autos on the 6th of December 2016 for the supply of 350 cars. Inti Okoto cars 350. You say Onko Public Procurement Authority. And you see, sa Public Procurement Authority sa embrawe. Embra ba kubia MPP for say eberi omo pa because omo time omo use sa embra no. Inti ya de we mami. And what time I know what you deal with ya. It was time I need to aba. December 5th December in the likes. So, it's some way. It's some way. I say the vehicles in question comprised 150 Chevy Aveo saloon cars, 100 Chevy Sparklight vehicles, and 100 33-seater Isuzu buses. Maslock thereafter applied for and obtained tax waivers in respect of all the vehicles to be supplied by Mac Autos. The unit price quoted by Mac Autos for each Chevy Aveo was 74,000 Ghana cedis. That was $18,883. The investigators, however, found that within the same year and exclusive of duty, Mac Autos offered the same vehicle at a retail price of 47,000 Ghana cedis. That's $12,000. Similarly, the unit price quoted for each Chevy Sparklight was 65,000, whereas the corresponding retail price offered by Mac Autos during the same period, exclusive of duty, was 35,000. And company now what they contract no more just a day to abatu no, and 2 days to abatu no. One kwanko siki PPA approval. Secondly, company no cars omo kokoto no omo double price no. Into obabe koti say bia car back ye turn 70,000. Now so that same company no doing sa year no aton sa cars no so ama ordinary people at the price of 35,000. So these were the charges are now I want to read the ruling from the judge, right? And so the judge goes into particulars of the charge. Once a decision, the judges know a take a decision. That's what they do. They want you to understand until they will come out with the charges, and then now after they are done with the charges, they will give their ruling. So the ruling is what I want. But basically, the judges were sort of giving us the overview of in some way the abo mami 94 page no. Utumi hune say charges no bebre na and I say ama adosun sa. So this is 79 77 counts 80 statements of offense. Now let's go to trial, conviction and sentencing. Now I say the appellant was present for the greater part of the trial but ceased to attend when the proceedings had reached their latter stages. On 30th July 2021, she applied to the High Court for the release of her passport to enable her travel outside the jurisdiction for medical review. The court acceded to the application upon the express condition that she would return and appear before it on 10th October 2021 for the continuation of the trial. She did not do so. Notwithstanding a repeated adjournment afforded by the High Court to secure her attendance, the appellant persisted in her non-appearance. Also on 18th January 2022, the High Court held that she had absconded in breach of the terms of her bail and directed her sureties to produce her on or before 22nd December 2022, failing which their recognizance would be forfeited to the Republic. On 24 January 2023, the court accordingly ordered the forfeiture of the sureties bonds. In the end, the learned trial judge was satisfied that the appellant, though duly notified of and fully aware of the subsisting proceedings, had by her own conduct disabled herself from participating further. Inti judge ne try in sequence of case no the see what you say. Inti no case no na ekoso no oba court fine. But a do later side of the case no eno ka so yare inti no person kwa abruchi ne ma ne koye ba afi no person be ba biem. It was say the trial proceeded to its conclusion in the absence of the appellants, though the second accused participated throughout. The prosecution called 7 witnesses: Stephen Amwa, PW1, then CEO of Maslock, Samuel Kwena, PW2. Inti MPP for Moka say chairman to me case no. The entire year you so chairman to me ni obi ye juma the entire year you so no. Someone say almost one more time. Omo you so CEO of Maslock no. The then CEO of Maslock, right? MPP time the then CEO of Maslock. Okay, we ye nipa crow by after maame no. Eno mo yusu etia maame no. But almost also yusu obatampa ni no etia maame no. Maka obatampa story no, right? Omo yusu inti obatampa ni no no ne maame ni ye ejuma. Omo yusu the board chairman of obatampa, the appellant's driver. Inti maame na nkasa ne driver. Inti mo amoka chairman untu me denta na yusu ono ani ni petia no. Maame nso ye yusu ono ane driver etia no. Criminal cases ne sanity. Francis Bando, head of finance at Maslock. Philibewa Ewa, who is the managing partner of Bafo Ewa and Associates, retained to audit Maslock. And Kodia Baswa Penyin Chum, field desk officer at Iyoko. Also, the learned trial judge found both the appellant and the second accused guilty on all counts and imposed sentences in the following terms. Inti or say judge no fine no say mamine dibone any sentencing no. Now let's go to this judge Ninsem Nimu, right? Now I say in respect of conspiracy to steal, the appellant and the second accused were convicted on count 5, 7, 9, 11, 13, 16, 18, 20 and 22. The appellant was sentenced to 10 years imprisonment with hard labor, and the second accused to 5 years imprisonment with hard labor. In respect of conspiracy to steal and stealing, the appellant and the second, and also Yamano. Also, in respect of willfully causing financial loss, in respect of conspiracy, so I think at this point we know the story. In respect of causing loss to public property, the appellant was convicted. We know the story at this point. Because the charges are many, the judge will have to treat every single charge. Mumfanche 78 counts. Charges number 78. This is serious. Now, the grounds of appeal. Also, despite being absent from the jurisdiction, the appellant appealed her conviction and sentencing to the courts, to this court on 9th May 2024. Naturally, say, judges are eternal case nesono. Mami appeal way our year and the NDC time. And I think that is the understanding that was in growth 40 years here. Or yeah, appeals no 2024. When the MPP was still in power. And there are semi-court appeals court. Also, the appellant set out 9 grounds of appeal as follows. And say, A, the conviction and sentence of the first accused appellant for the offenses of conspiracy to stealing, conspiracy to cause financial loss, causing financial loss to the state, causing loss to public property, improper payment of public funds, unauthorized commitment in resulting in financial obligations to government, blah, blah, blah. Or say, is unreasonable and cannot be supported, having regard to evidence on record. B, the court below erred in convicting the first accused for conspiracy to steal and stealing. And so, the grounds, no. It is the judgment that I want to read. Also, summary of the submission of the appellant. So, that is the summary. Now, I want to read the judgments. So at this point, they are explaining the case. We are understanding the case and all that. Now, as a summary of the submission of the respondents, a submission of the, yenti mame no, ne lawyer, asemo de call ya judges ne jina so a ruling way abano. I think said that would be an interesting one, right? Inti yetie we ne call judge no edie. As a summary of submission of the appellants. As a counsel for the appellants argued grounds B to H under the omnibus ground A. Or say it is the appellant's case that the charge sheet which initiated the criminal proceedings is defective and cannot justify the appellant's conviction. The appellant claims that counts 5 to 71 are defective because the particulars of the offenses in the conspiracy to stealing, conspiracy to willfully cause financial loss to the state, and causing financial loss to the state charges do not show any acts, omissions, or transactions involving the appellant. Also, the appellant argues that the charges lack specific details about her dishonest appropriation of funds and the acts of omissions that led to financial and public property losses. This is similar to the charges on improper payment of public funds, which were not verified due to the prosecution's failure to disclose existing procedures that the appellant allegedly violated. Additionally, the charges on committing the government of Ghana to a financial obligation without authorization do not specify the transaction, the entity involved, or the required authorization. Inti ne lawyer call court na semo can say charges amode bo me client ni na no. Nyan say nim. Because one, mo trese misappropriation. Okay, yate. Mo say Ghana sika ye man 1.4. Mahama ka say won onkoche sika ma edwadefo. Right? Omo nyama ahye. Sika no mukuku hu say emu 500,000 or de koye ade ensem fata. Ade ananke wo say o de kokoye no. Wanfa nkonkoye. Ne lawyer asem a wo kan say mo amode asem we etia no amode aba court no. Mon tre wo court de wo de 500 ne kokoye ye. Ebia mo pesa mo tre say okay, ye charge ne say misappropriation. Or the 500 sika no yesi wonfa 1.4 enkoche emadwadifo okoye no 1.4 no okoche emu okoche kakraba 500 na aka no ebia or the kori kebab na no mo the evidence about to oni ehu so okay yesi koche sika madwadifo no de akwa kori kebab but the mo pesa mo trene say sika no 500 no or de akwa koye bibi foforo mo ntre bibi foforo de sika no kokoye nso mo antre nti ohwa ne lawyer no ensem a o raise no because ne lawyer no ensem o be raise and be ma judge no ejina so aka so okay ma je ne lawyer no ensem wedi. That is why I said it is important e be read lawyer no ne issue a o de buy. Enti basically no lawyer no nsɛm a no ɔka no wo pɛ sɛ mo kyerɛ sɛ o maame no akɔ bibi sɛ ne ɔkɔkɔ spend sika bi abɔ Ghana ka mo ntrɛ evidence a kyerɛ sɛ abɔ Ghana ka ɛka na mo sɛ abɔ Ghana no ɛwɔ he mo sɛ when you sue the right procedure ɛna ɔde kɔkɔ spend sika bi mo ba court no mo antrɛ the right procedure yɛ de spend sika inti procedure no use yɛ no ebesi de hu sɛ yɛ right and sɛ nyɛ right inti basically no ne lawyer no nsɛm a wo raise yɛ no or say in advancing the submission learned counsel for the appellant placed reliance upon the Republic versus Ernest Thompson and 4 others criminal appeals number and a boho dated 17th blah 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 the submission or say as I understand it is that decision states the governing standard by which the proper formulation of a criminal charge is to be judged. On the footing, counsel contends that a charge is duly framed only where it gives the accused sufficient notice of the nature of the act alleged against her, being the act said to constitute the conduct which the law has prescribed and to which penal consequences attach. Therefore, counsel submits that the absence of these details violates Article 19(2)(d) of the Constitution and Section 1121 of the Criminal and Other Offence Procedure Act 1960, and a conviction and sentencing based on these defective charges must be set aside. It's quite interesting. It's quite interesting. Ghana mbra. You see, a charge is duly framed only when it gives the accused sufficient notice of the nature of the act alleged against her. Ghana, you see, a charge you be a nipakrona or some man tias ye bonia wedi. Or say, being the act said to constitute the conduct which the law has prescribed and to which penal consequences attached. Ni atre nipakrono punishments. As therefore, counsel submit that the absence of these details inti maame no issues na yede abono no omo mu feel say yentre wo mo bone a wo mo edi bone ben and to most of criminal cases no lawyers say use use line we pa chema who to media no grass on krom use. Now say the appellant submits in the alternative that even if the charges are held not to be defective, the prosecution failed to discharge the evidential burden of proving every essential element of the offenses. Into the lawyer say the prosecution Gofredame when to me improve maame ne nsɛm a yɛde to ne so no yɛntumi improve wɔ court evidence bi anyway to me prove in nsɛm a ne yɛde to ne so sɛ wɔ say sika 1.4 ɔmfa nkonkɔma adwadifo 500 every baby untumi improve asɛm ɔmo ka no so untumi improve wɔ court or say that burden counsel contends rests squarely upon the prosecution under sections 11(2) and 13(1) of the Evidence Act 1975 NRCD 323, read with the constitutional presumption of innocence guaranteed by Article 19(2)(c) of the Constitution 1992. It is therefore argued that the learned trial judge impermissibly shifted that burden to the appellant by requiring her to establish her innocence, notwithstanding the prosecution's alleged failure to make out even a prima facie case. Intino, say criminal case be abesha say obi be a friend of prima facie. Prima facie no etre say. Okay, yesi Kofi akwa kowi akoko. Right? Answer na ebe di asem no in the first place. Akoko no ayera. Yesi Kofi akwa kowi akoko in the first place. Answer na ebe di asem no akoko no ayera. Answer na ebe hwe asem no hu se eye no korekra no. Time na ne ye ka se Kofi akwa kowi akoko no. Sa time no na Kofi owo area na akoko no wo na na. Engrofo tre se omoni bo Kofi so hu se no de akoko na hye na taare mu. later ye ko fifie ya kwa ko hu ne se akoko ya na se ayre edane nkwan mu akoko nam da ne nkwan mu eno no broni friend prima facie case ye betena asem ne so ba ansa ne ye betena asem ne so no bibia da ho bia atre se asa asem no kwai wom but yesi kofi akwa ko wi akoko bi na yakwa ko hwe na akoko na yesi kofi ewia se wakwa ko wi akoko ekum na edi ni akoko se sa akoko no owo ho bibia woda na no da still yesi kofi ewia akoko eno na enye prima facie nti ho na asem ni ngina nti maami no lawyer se tre se in the first place kra no maami gofredami ntumi amfane prima facie ntia no gofredami ntumi enya case ntia maami se okay we etre se indeed odibone no o see also this sika kokoma adwadefo sika no 500,000 afa baby evidence ben etre se 500,000 afa baby adwadefo yo mo aka atre so mo nsa anka sika no ombe so mo tre se prima facie eni ho ena judge ne nso no maami ne de asem ato ne so na judge no mom expect say maami ni mom be prove ni innocence instead of gofredame mo prove say indeed maami ni dibone inti yesi wo akwa wi akoko bra na be tre yen wo mom bra be prove wo ho tre yen say akoko no wiaye na nipa kra ono ede to so say we wi akoko no ye gyan no ono no on ma prove bi etre say we wi akoko wo mom ni ebisa ene ye accuse you say tre yen say akoko no wiaye. But omo person mo trese Ghana mra na sanity. Or say as regarding the charge of stealing 500,000 Ghana cedis, counsel argues that once the appellant denied in her Yoko statement that she authored the letter acknowledging receipt of that sum from Obatampa, it remained for the prosecution to prove both authorship and receipt. Inti Obatampa story na yedin kan wansem na ende aba. Yemano 500,000 Ghana cedis. Obatampa ni no ema ne sign receipts and outro ho receipts. You see the receipts no ba betre no. But ono tre iwokofo say signature yi a semi signature nanso men kai se ma sign receipts bi say in the 500,000 ya mo kan ho asemi de media mi hu hwe. Ne lawyer asemo a waka ne say se ma me na ka edru sa level no afi e wo se aban mum ene de evidence ba wo betre say indeed maame no 500,000 afa ne nsase. It was for the prosecution to prove both the authorship and then the receipt. So the complaint is that the learned trial judge instead required the appellant to prove that she neither wrote the letter nor received the cash. Afi yesi judge ni mum ena otre maame ne say umom bra be prove say enye wo na wasane ade we umom be prove say enye wo ena wonsa ka sika no. Also reliance is placed on unreported decision of this court dated 30th July 2024 in suit number H2/22/2023 Republic versus Kessel Atoforsen and Omokoti Atoforsen there no and also Sa and all that, and it goes on and it goes on and it goes on. So basically Oshe you all know where it is getting to. The video is getting very long, but at this point you understand. In the analysis of the grounds of appeal, the respondent's preliminary legal obligation, the respondent preliminary, I want to see the judge. Now let's go to the judge's ruling. And see, at this point you understand what's going on, right? If yenina yesua adie baako ewo Ghana ha, one thing I've learned from this thing and say it is extremely difficult to Ghana has say yes obi edisika e be chinipa krona tum no difficult because Charlie yenka no kwario ye kambra so obi ewie sika pa no we disika no pa yes o that umum na bra be prove beyond reasonable, and that is the law. What can you do? That is the law. I want to see the judge's ruling. That's what I want to read. So at this point, we understand the case, at least. Now, judge no any or say harsh and excessive sentencing. Or say having concluded that the conviction on all counts must be quashed. Okay, so let's go up. Judge Ninsemena Walker. Or say, in my judgment, the evidence adduced at trial did not prove that approval of the board of the Public Procurement Act had been withheld. Rather, the evidence showed that the then Minister for Finance confirmed to the Public Procurement Authority the relevant financial arrangements for the contract, as the authority itself had required. As the PW1's evidence further confirmed that the appellant did not authorize payments for the 350 vehicles during her tenure as Chief Executive Officer of Maslock. It was P1 who, after assuming office and renegotiating the unit price in 2017, authorized payments to Mark Autos. Those payments continued in 2018. Okay, into judge in some can say evidence that we did say, my meaning some more tone so say car, my meaning crano, and yan the time na mutia caneka, mu MPP for na mobabetia caneka. Bansa na mu MPP for mubetia cano, e cana crano. Mokramo koko renegotiate e microphone te cano, e price eso. It is a more idea when in na e ka charges ni hubi e de bomb no say, as a wabo minor chrono because car bia wo yes wo kotono na price no e wo soro dodo a car na kra no wentuaka mo na mo ba betuaka ne kan ti di ndia na mo mo pese mo de sobo ne bono say I mean this an interesting judgment, right? And it's interesting that you have to read to get to know the details of the issue, you know. Or say harsh and excessive sentencing. Or say, having concluded that the convictions on all counts must be quashed, it is necessary to say no more than this upon the final compliance by the appellant that the sentence was harsh and excessive. A sentence is not an autonomous judicial order. It is the penal consequence of a valid conviction. Where the conviction is set aside, the sentence is deprived of its legal bedrock. The appellant's question whether a sentence is excessive is intelligible only by reference to an offense lawfully proved and to the circumstances in which that offense was committed. Once the finding of guilt has disappeared, there is no judicial foundation upon which any assessments of proportionality can properly proceed. It would therefore be both unnecessary and conceptually unsound for this court to consider whether the punishment fitted a crime which on this appeal has not been established in law. Such an exercise would risk elevating a residual legitimacy to a sentence whose indispensable foundation has ceased to exist. The appellant is not entitled merely to a reduction in sentence. She is entitled to the more complete relief which follows from the quashing of the convictions themselves. In those circumstances, the ground of appeal directed to sentence is rendered moot. I will decline to express my view upon it. Conclusion: it has long been the golden thread running through our criminal jurisprudence that the prosecution must prove the guilt of the accused, and that this burden never shifts unless the enabling statute or law has expressly and clearly said otherwise. You know, this is quite interesting. But basically, no judges no a ruling any Osha judge Bakon, and then Emmanuel Ankama J.A. and then Samuel Obin Diewu and also say I agree, and Emmanuel Senyo Amedahe and also say I also agree. So these you know, this is, I hope at this point you understand what's going on and what the judges are saying. This is quite interesting. This is an insight, right? Case no. But basically, as someone more can say, Gofredami could not prove name sema or the two mamine so. It's able to me about say mamine no ye born any day, but Gofredami to me improving. It's based on prove Gofredami to me improving into no. Na can you can say judge no original so. Emma mamine 10 years. Asem no nini na no. Oh my Ghana.
Ghana ni bia wutie me no. Book we eye asset back one. I was say wo keep e wo fie. To book we ma wo ho. Toma oba. Toma obi biara osumbo e wo wabrabo mu. Wadamfo. Obi a opese odi ye wabrabo mu bia no. To sa book we your friend the Ghanaian investor. Na sa book we bet show different forms of investment a obetumi aye e wo Ghana ha. Licensed investments. The first one e ya de bia your friend emergency fund. Book we bet show send you be set up emergency fund. Abrabo aye boy bibia betumi ato. If you have an emergency fund, ebeba na aba be save you. Oka betumi asay wo kwan so. Obetumi ayare, oba betumi ayare, ni na emergency fund no ebe take control of all those situations. Book no besan so atrewa ade bia ye fe na endowment fund. A obetumi dia protect wo ho any future. Na sa endowment fund no nyame mpengu ukokonya accident na untumi nye adwuma bioma, it will take care of you for the rest of your life. Book no besan so atrel senya obe set up a personal pension fund. Enkrofo bebre eye adwuma wie ekọ retirement, omukọ retirement we are no mo ho aba betwe omo. O set up a personal pension fund. That will not be your case. Most importantly, book we betray how to invest in the Ghana Stock Exchange. Now Ghana Stock Exchange investment, basically, it means you are buying ownership of Ghanaian companies. Now Ghana Stock Exchange, it is one of the best performing markets in the whole world. A lot of people are making money from the Ghana Stock Exchange, but they don't know how to invest in it. Book we a better idea. Your investment be why a friend of mutual fund. Book we better how to invest in a mutual fund. Now mutual fund, you don't need to be rich to invest in a mutual fund. I remember an example. You find say wa woba fresh. Now what per license mutual fund e Ghana has say opese odi usikashim. Say o to me invest 500 cedis every single month. E a Ghanaian mutual fund moi. By the time I will be 19 years no. Now I done a millionaire. You find say o wa fa CB we did 10. Opese that chibi odi every month for 500 cedis e mutual fund boom emano. By the time I will bano and I will fast no obedi 29 years no na oye millionaire. Wankasa utie me we di 40. Now so sha unye investment bia eno ane say obeye mutual fund every month for 500 cedis eshem. By the time obedi 59 years no na wenya 1 million Ghana cedis. Into mutual fund no, that is how it works. Small money every single month. By the time embre ebebano nesikano ayekese. Book we better sanya mani na. Sa ope book no ni PDF anase ni tree video a. Free. Anase WhatsApp number na ewo book ni so sisia. Na sa we Ghana ni na wa brochure. Now pay hard copy of the book a very simple call Amazon. Na search for the Ghanaian investor. Place the order. Baby will be a best shape. Eddie Abreu. Medasi.